Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host. Lovely Saturday afternoon once again here with us, live on BWTV, and we hit on the community with The Community and the Law. My name is Oreku Frimpong. Today is Saturday, the 15th of March, 2026. Reasons why a UK visa application may be invalid and how to avoid that is what we're going to have a discussion on this afternoon. And we so graciously grateful that we have lawyer Charles Asma from the stables of BWF Solicitors to help us look at this topic. This program, The Community and the Law, is brought to you by BWF Solicitors, our trusted partners when it comes to the law. When we're talking about BWF Solicitors, there's so many reasons why we should be grateful and appreciative. BWF Solicitors and The Community and the Law. Next.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
We are live. This is BWTV, and we're bringing you the community and the law. My name is Uriku Fripon, and I have the privilege and the honor hosting this event for the next 2 hours. I'm inviting you to come join us because it's a very important topic we are looking at this very particular afternoon. Reasons why a UK visa application may be invalid and how to avoid that. We have always come your way every Saturday afternoon by courtesy of BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors is located on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. They work Monday to Friday between 9:30 in the morning and 8 p.m. in the 6 p.m. in the evening. Call and book an appointment and see any of the lawyers on 0208 493 7340. 0208 493 7340. If you're in Ghana, they have an office in Ghana and you can reach them on 055 589 5959. And in all emergency situations, call 0044 77 12 76 1884. 0044 77 12 76 1884. Looking at all forms of immigration issues, looking at any update that comes from the Home Affairs and the Secretary of State for Home Department, and all the other things that you need to know when it comes to all the bits about the legal situation here in the UK. BWF Solicitors sits on top when it comes to our community. So reach out to them and get the help you can get. BWF Solicitors. People have used their services and they're so grateful. And I believe our friend Faustina is one of such. And Faustina is saying, I'm so happy to finally get a visit visa for my mom after 2 failed attempts. BWF Solicitors came through for me, and by the grace of God, it's been granted. Thanks to the amazing team, especially Chelsea, for all the help and support. Just so you know, Chelsea is one of the members of staff in the Ghana office. So, Faustina, thank you. BWF Solicitors is grateful that you have decided to let the whole world know what you have had and the benefit you have had from them by using their services, and of course, expressing that as well. This is positive feedback. We're grateful for that. And those of you who have not done that, yes, you can do our client review. Get to Google and look for BWF Solicitors and give us the review, or you can visit any of our social media pages: YouTube, Facebook, LinkedIn, TikTok, and leave direct messages there. Yes, we'll pick them up and share with everybody else. So, Faustina, thank you. Thank you so very much. BWF Solicitors is grateful. I mentioned that if you're looking for updates from the Home Office or from the department, the Home Department, so to speak, the Secretary of State often puts out several things that people need to take note of. And especially so, if you have really followed immigration matters here in the UK, we read from the Secretary of State for Home Department's corner, you would realize that between March, beginning of March, so to speak, and the beginning of April, several changes come in. So I would want you to keep your eyes peeled and watch the space, because anything that comes up, we will bring you. On the 9th of March, 2026, there was this update that dropped, and I want to share that with you. It's talking about key to overcoming the proposed 10-year route to settlement. Remember, the Secretary of State last year proposed that several changes were coming, and remember we asked you to go online and complete a survey. Well, whether you did it or not, the time for that survey is passed, and several things are coming up. One of them, as I mentioned, is the key to overcoming the proposed 10-year route to settlement. The Secretary of State for Home Department has, as I said, proposed a new 10-year pathway to settlement. However, Both the November 2025 and March 2026 statements indicate that certain work categories will be exempt from the proposed 10-year pathway. And what are these? Public servants, medical doctors, nurses, high income earners, that is 50,270. If you earn that from that and above, you would go through the 5-year route. And if you earn 125,140 pounds uh, per year, from that, yours will be 3 years. And the other category is those who work in the local community, especially those who have volunteered. 5 to 7 years will be how long your route will take you. Care workers have been identified as those who the 10-year pathway will encompass because they are considered low skilled. So we will be putting these to Lloyd's Assessment to help us get into that a bit more. But we would want you to take note of this because this is an update that's come, and some positive or whatever it is that you want to have out of that we'll explain to you. But in the meantime, let me say once again, thank you to BWF Solicitors, and I'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Well, I was talking about the update, and I believe that you are quite eager getting some more detail of that. I mentioned also to you that if you want to reach out to BWF Solicitors, you can contact us on our various social media platforms. Then again, there's another very wonderful tool that they have that we can take advantage of, and that's the website www.bwfsolicitors.com. www.bwfsolicitors.com. Now, you visit the site, you realize that we have the homepage, the practice areas, about us, resources, fees, contact, and also an avenue for you to book a consultation with BWF Solicitors. Now, the updates that I talked about earlier on, there's an article on the BWF Solicitors website that I would want us to quickly go through and read what Mr. Bernardo, senior partner of BWF Solicitors, has written that. And it says that the UK government is currently proposing one of the most significant reforms to the immigration settlement system in decades. The proposed policy, commonly referred to as earned settlement, will reshape how migrants qualify to indefinite leave to remain, the immigration status that allows a person to live in the UK permanently without immigration restrictions. Under the current system, most migrants on routes such as the skilled worker visa, family visas, or other settlement routes can apply for indefinite leave to remain after 5 years of continuous lawful residence. However, the Home Office has now proposed extending the standard qualifying period to 10 years for many immigration routes. The reforms form part of the government's broader immigration strategy aimed at reducing net migration and ensuring that permanent settlement is based on what the Home Office calls contribution to the UK economy and society. The Home Secretary's position and parliamentary debate uh, took place. There were discussions and the official consultation process took place. The government made it clear that it intends to move away from what it views as a time based entitlement to settlement towards a contribution based model. In parliamentary debate, MPs raised particular concern about the possibility that the extended 10-year settlement route could be applied retrospectively, meaning that migrants already living in the UK may also be affected. Um, we know that policy documents and immigration commentary suggest that the government is considering applying the new system to people already in the UK who have not yet obtained settlement, although transitional agreements are still under discussion. This retrospective aspect has been one of the most controversial elements of the reform. So let's look at some of the features of the proposed end settlement model. One, extension of the settlement period, that is standard route to indefinite leave to remain increased from 5 years to 10 years. Another feature is that longer routes for some occupations have been proposed. So workers in roles below the RQF level 6, as degree level, may face settlement routes of up to 15 years. The third feature of this one is the contribution based settlement. And this talks about settlement eligibility, which may depend on earning levels, employment history, English language ability, demonstrated integration in the UK society. The fourth feature of the new proposition is the implementation timeline. What timelines are we looking at? Number four, implementation timeline. What timelines are we looking at? We'll scroll up and get that through to you. Well, immigration rule changes obviously are expected to begin around April 2026, subject to completion of consultation and parliamentary process. So the article continues, and I would leave you to be visiting the BWF Solicitors website, www.bwfsolicitors.com, and you can read that. Well, having blabbed on and all that, let me bring in Lawyer Charles Asma to help us with some of these things, especially the updates that I spoke about and that long um, reading of the article. Very, very nice article, and I believe you should read it. And I would recommend to some of our immigration practitioners and lawyers to pick that one and read as well, because it's very insightful and has a lot of information in there. Last one, good afternoon.
Good afternoon, Brakuku.
Thank you very much for joining us. How are you doing?
Very well. How are you?
I'm fine. I found that article on the BWF Solicitors website, and I thought I would share with my viewers before I brought you in, trying to see if I can do a lot of legal magic there for people today. But yeah, once you are here, I won't even usurp your position. So I will pick up the keys to overcoming the proposed 10-year settlement route. Now, this 10-year settlement route, the consultation, and all the other bits around it, what's happening?
Right. Yes. So, I mean, we know that something will happen in 2026 to do with how people become settled in the UK or
Hmm.
gain settlement rather than wholesale time based process. Is going to be end process.
Hmm.
End process means if you want it, you get it. If you don't want it, you don't get it. What do I mean by you want it? If you want to settle in the UK, then you go through a process to settle, and more or less you keep yourself prepared to become a settled person.
Hmm.
And keeping yourself prepared means you learn the language up to a high level, you become accustomed to the voluntarism activities of the UK. You work, you earn, you contribute. You don't take from the government, but you rather give to the government and all that. Now, so speaking the language, which is the English language,
Hmm.
is going to be at B2 for everybody who wants to have settlement in the UK, as we
Right.
know from March next year. That's from 26th of March 2027. But for now, people will have to. That what it means is that if you really want to, you have to then prepare. They said there's going to be in April a lot of changes. Thank God it's been extended to autumn. And so it's better for those who were due before autumn to get it done. Now, much as people would say, "Okay, I've done 10 years, I'm going for indefinite," it's no longer going to be. And so some people, it may take longer. Other people, they can finish earlier. What are the things that will help people to finish the time early and get settled? One, earning and contributing. So if you are
Right.
earning about 50,000 plus, let's say 51,000 plus a year, that means you are contributing to tax more. And that will help you to settle in the UK earlier. And for
Okay.
those people, it's 5 years. You can settle within 5 years. So if you knew you were going to be settling within 5 years and you are still earning that, then you know that you are okay, covered. But if
Okay.
something changes, then it may take you longer. For example, if you were earning 51 and all of a sudden you change job and your salary reduces to 30 something, then you'll be contributing less and that will take you longer than you thought.
Right.
But mind you, those who are earning 51,000 are high level skilled workers. And for
Hmm.
those people, there's no way they will say, the employer will say, we don't need you. And so it's possible. Again, those who are earning 125,000 a year will be able to finish within 3 years. And this earnings must be continuously for 3 years. So 3 consecutive years is the standard.
Okay.
Then you settle early. 5 years, 3 years, you can settle. And you know that somebody earning 100, a skilled worker earning 125,000 a year in the UK is a real skilled worker.
Hmm.
Yeah, and that's what the country needs, real skilled workers. Yeah, so they will let you settle early so that you be part of the system early. Then those who are working in public sector, those working in
Okay.
the public sector, nurses, teachers, health professionals, doctors, of course, nurses are also doctors, social workers, and other public service workers, skilled workers, can
Hmm.
also finish early within 5, 7 years.
5 years. Okay. So,
And
so lawyer, if for instance I work with the local authority, even though I may not be earning 50,000, would that qualify me to get my indefinite within 5 to 7 years?
working public, what do you say, local authority,
Local authority.
but as what?
Would I deem myself as a public servant?
As what? That's the point. because the
Mm-hmm.
public services are defined, as we have mentioned a few of them. So working as an administrator at the local authority may not be part of that.
Okay.
Yeah, but once the law is set out properly, we'll know the specifics as to
Okay.
what those public service rules are. But for now, we've mentioned a few. We also know that the government is clear on voluntarism, so that those
Yeah.
who volunteer will be able to complete their settlement early. Settlement early. So you can volunteer in any sector. You can volunteer at the local authority, volunteer at the charity sector, within the charity sector, helping the community, doing this at the churches, all sorts of voluntary activities. You can even volunteer at your local schools
Mm-hmm.
doing certain support activities. You can volunteer at your local police station if there is anything to do there, and so on and so forth. Yeah, so all that will then accumulate into time, and you have to evidence it.
Mm-hmm.
Benefit. Those who take benefit will stay longer or will delay in settling than those who do not take benefit. So
Mm.
if you work and you earn and you take back, you pay back literally in
Okay.
terms of waiting time.
I've
Benefit,
gotten myself into my thinking mode, and if you'd permit me, lawyer, I'm earning not up to 50,000. I'm not in the category that have been listed there. For instance, I am a care worker and I earn about 29,000. Then I realized that it may take me longer to get my settlement. Would I be able to take advantage of number five, for instance, where I volunteer in the community as much as I can? So then, when I evidence that, I will be able to put up a case to say, I need to have my indefinite earlier than the extended period.
well, if somebody is, did you say somebody who is not earning enough or somebody who was earning enough?
Who currently is not earning enough, or probably even within the 5 year period, may anticipate that they may not earn enough. Can I use that strategy, if I'm permitted to use that word,
Yeah,
to
voluntary.
volunteer a bit more and top up with my salary, really?
Yeah, literally. If you can't contribute money, contribute effort, literally.
Hmm.
So you see the contribution spectrum:
Okay.
money contribution and kind contribution.
Okay.
So if if you don't have time to be kind, then work and use the money to show kindness to the government, and that will cut it down. But that
Okay.
one you contribute more because it's clear 51,000 or 125,000 a year in terms of your earnings. But most of the people who are going to be found in that situation where their income is not enough are the average people. For most
Hmm.
average people will be earning between 20 to 30, and a little few will be earning between 30 to 40. So most of them between 30 to between, let's say, 25 to 35. It's not enough to gain points through tax. And so you have to gain point through voluntary work. And in terms of voluntary work, you are able to finish your settlement within 5 to 7 years instead of 10 or more years. 5 to 7 years means that you're able to save 5 years or 3 years, depending on how much you volunteer. So if people can start today to volunteer, then by the time the rules come and you are due for indefinite, you would have clawed accumulated time. We don't know how it's going to be counted and how it's going to be assessed and all that, but you
Okay.
must have the evidence that you are
That
doing
you've
this
been
work.
volunteering.
Just like when you go to work and you are an agency staff, you do timesheet, right?
Hmm.
If you don't do your timesheet, what happens to your money for the week?
So you won't be paid.
Because it didn't come.
You didn't come. Yeah.
And if you came, you didn't want to be paid. That's why you didn't present timesheet.
Oh, well.
The same thing. So that's how it's going to be for the voluntary work. Once
Mm-hmm.
you volunteer, you have to tell the people, the organization or service provider that I'm doing this for a reason. So mark me present, literally.
Okay. So,
Yeah.
if, for instance, I am volunteering in my local church, do I have to get the church authorities, the elders, the pastor, to give me evidence of that by way of probably a letter or something?
Yes. Yes. And they have to put it, they have to quantify it per se in terms
Mm-hmm.
of hours, in terms of days. So Charles Asthma is living in the local area as he has been supporting our food bank, wherein he goes around collect the food from stores and homes and keep them in the bank, and he will be there every week or every whatever to distribute. He will be timing, so they will describe what you do and how long you've done it for and
Mm-hmm.
how even hours.
Okay.
Yes, but I
Okay.
don't know whether it's going to be every church though. And you know how we abuse things.
Mm-hmm.
When they say every church, new churches will spring up with a view to give
to,
voluntary
to make up
certificate.
volunteering opportunities for people, isn't it?
Yeah, so sort of. I don't know how they're going to, but I'm sure it will be open enough for every church. And maybe they will say the church must be recognized. Maybe they will say that, but I don't know how. And again, those who are on benefit are
Mm-hmm.
going to be affected. If you're on benefit for 1 year, you have to wait for 15 years. And if you're on benefit,
My other question, sorry for cutting it. My other question is now the global proposition has come. We don't have the fine details, don't do we? And are we expecting that to really come up? People will absorb it before it really kicks into effect.
we are still within the consultation. I suppose the consultation is nearly over.
Hmm.
Parliament has debated it, and it appears that it's going to work as planned. So, if people have things to do, we have to start now. English language is going to be B2. So,
Hmm.
if you think you are not sure about your English proficiency, you have to start learning
Hmm.
and write the exam and keep it. At least, if you know that you are going to be due from next year, since you can't do B1, you have to do B2 in advance. Because if your indefinite will be due in April next year, then you are going to be affected.
Yeah.
And the B2 will be across board, will cut across everybody. Then the next thing we know is that you don't have to owe debt in the UK, be it with a bank, credit card, or loan, or whatever you took, you didn't pay back, or um, NHS, or any other lender for that matter. If
Hmm.
you owe money in the UK, they said you cannot become a settled person if you owe money.
Okay. So yes, the updates lawyers mentioned, and I'm going to reiterate that the English language is going to go to B2, and the other bit is the route to settlement, where the Secretary of State for Home Department has made some propositions. Um, Public servants, medical doctors, nurses, high income earners from 50,000 upwards, 125,000, and work in the community. So it's either money contribution or kind contribution, so to speak, as lawyer has explained. And then you could reduce the amount of time that you can have your settlement. If you want further details, I will propose that you have a chat with BWF solicitors. They are open Monday to Friday between 9:30 and 6 p.m. You can call and book an appointment and speak to them on 0208 493 7340. 0208 493 7340. BWF solicitors is also gracious enough, and they are bringing us the community and the law. Um, Apart from the updates, they also help us to understand certain aspects of a law, and they put that in small bits we call the nugget. Our nugget for this week is what we talking about, and paragraph ST 39.1 and ST 39.3A and B sub section I or II of appendix student to the immigration rules. Now it says that a dependent partner of a student will be granted permission which ends on the same date as the student's permission. The dependent will have no access to public funds. And where the visa was granted for a period of less than 9 months, or the student is studying a course below degree level, there will be no right to work. Working in breach of your leave condition as a student dependent is an immigration offense. As I said, this one is from paragraph ST 31, 39.1, and 39.3 of the appendix student to the immigration rules, section 24 of the Immigration Act of 1971, as amended. Well, um, let me put myself in the shoes of somebody who might be kind of confused. We understand that people can bring their dependents again, and students were included. Was that the case? Was that correct?
First off, yes, student
Okay.
cannot bring their dependent
Okay.
unless certain exemptions apply. The
Mhm.
exemptions are: one, you are a student and you are studying an MPhil program, Master of Philosophy program, because that's a research program.
Mhm.
Or you are a student studying Master of Research, MRes program, that is also research program. Or you are a student studying at PhD level. Or you are a student studying at any level, whether taught or master or research program, but you are sponsored by an international organization or government.
Mhm.
That is that you can also bring your dependents still. So those are the exemptions that apply to bring your dependent as a student. Otherwise, you cannot bring your student. What they are now saying is that if you're a student, your focus is to study.
Mhm.
So come and study and let your family pray for you to support you wherever
I
they are.
like that. They should pray for you and stay away.
Yeah. So that is that. But with the
Mhm.
nugget, so we can then, because there are still exemptions, people who can still bring their dependent if they meet the conditions. This criteria, this nugget is still relevant, and the rule therein is
Mhm.
relevant to those people. So those people who qualify to bring their dependent, that's how we put it. Those people who qualify to bring their dependent, the rules say
Okay.
that the course should be at least more than 9 months.
Okay.
And whatever your main partner the student has is what you get as a dependent.
Mhm.
And you are allowed to work. The only thing you are not allowed to do is to access public funds. But
Okay.
if the main dependent student was given more than 9 months visa to study, then you will be given same time as your main. If your main has got 1 month to go at the time you are applying, you'll be given 1 month. However, you have the same right that he had when he was given. As a matter of fact, you even have more right because you, the dependent, can work unlimited hours, but your
Mhm.
main person, who is the student, can only do 20 hours during the study time or term time, and vacation more hours than if it's not vacation, only 20 hours. But apart from that, those who cannot, if you are given less than 6 month visa to study, some people do short courses,
Yeah.
and those ones you'll be given less than 6 months. If your dependent had opportunity, because you are sponsored, for example, your dependent cannot work because you are restricted on that basis. So that is the difference between what is going to happen to such students who can still bring their dependent, and what will happen to students who were able to bring their dependent prior to the changes. But the bottom line is that you are a dependent of a student. You have to keep to the conditions of your visa and make sure that you do not go against it. Otherwise, that will be a breach.
So what the nugget is telling us, and based on the quote we have from paragraphs ST 31, 39.1, and 39.3, is that students can bring their dependent partners, if you are in that category, and be granted permission which ends on the same date as the student's permission. The dependent will have no access to public funds, as lawyer has explained, and where the visa was granted for a period of less than 9 months, or the student is studying a course below degree level, there will be no right to work. So take note of that. And there's a caveat here, in fact, a warning, maybe so to put it. Working in breach of your leave condition as a student dependent is an immigration offense. Don't go forward foul of the law, because it could have dire consequences. This is the community and the law, and brought to you by BWF Solicitors. We thank you so very much for joining us. If you stayed with us up to this point in time, we deem you a very important personality, and we want to acknowledge you. So please leave your comments in the comment section down below, and also announce your presence. Let me quickly do this housekeeping, even though it's in the middle of the program, and acknowledge people who have joined us. Tilly Duma has joined and said, hello, lovely family. Thank you very much, Tilly, for your time. And obviously, yes, you're asking people to kindly share, comment, and also like the page. Sandra Fraser, thank you, Sandy. Good afternoon, all. Please share when you join. Thank you. Thank you as well. We have Debbie Obed. Good afternoon, Lawyer Obed. Thank you. Good afternoon as well. We appreciate you for coming. Adesafo is here and says good afternoon to everyone. Thank you, Adesafo. God bless. We have Ohinitufor is asking the question. Yes, what I would want to reiterate is that when you have a question to put to the lawyer, you can put that in the comment section below, or you can text it to us 07399208468. Or when the lines are active, you can call us and speak to lawyer directly, 0208 493 7345. So keep your comments clean and ask your questions. And of course, when we get to that point, we will be asking lawyer to help us answer them. W. But yes, you're talking about your B1 English thing. We'll come back to that later on in the program. And having given you the nuggets, I often ask you to help me unravel a scenario. Let me do that now. Delilah was granted leave to enter the UK as a dependent of Samson from the 30th of September 2024, running through to the 31st of July 2025. Samson was granted leave to enter the UK as a student from the 2nd of February 2024, running through to the 31st of July 2025. Delilah, it's a lot of steps, and I will want you to pay particular attention, okay? Now, Delilah joined Samson in the UK in November 2024. On the 8th of May 2025, she was arrested by the border force when she was working at a warehouse. Her leave was cancelled without a right of appeal, and she was detained pending removal from the UK on the 29th of May 2025. According to the border force, Delilah breached conditions of her leave as a student dependent, and thus has committed an offense under Section 24(1) of Immigration Act of 1971 as amended. Remember, Delilah was granted leave to enter as a dependent of Samson, and the leave was granted between the 30th of September and 31st of July 2025. Samson, the person Delilah is depending on, was granted leave to enter the UK as a student from the 2nd of February 2024, and that was to run through to the 31st of July 2025. Check the time Delilah joined Samson in the UK. That was in November 2024. Now, a couple of months later, in fact, 6 months later, more or less, she was arrested by the border force when she was working at a warehouse. A leave was cancelled without a right of appeal, and she was detained pending removal from the UK on the 29th of May 2025. They are saying that she has breached the conditions of a leave as a student dependent. So, what advice would you help Delilah with? Would you say to her that she has no reason to remain in the UK because she has breached the conditions of her leave since she had less than 9 months left for her visa to expire? Are you also going to say probably that Delilah cannot be removed from the UK because she has a spouse who has a valid visa to leave, valid leave to remain in the UK until the 31st of July 2025? Or could it be that you will tell Delilah that she should seek a judicial review of the decision to cancel her leave because she has not breached the conditions of her leave as alleged by the border force? Think about that. Today, I know it will get you doing some very critical thinking. Yes, that's what I want you to do. So, do that. We will go to the discussion bit, and when we come back, I'll bring it up again. Maximus Banks, thank you. Good afternoon to you as well. This is the first time we're joining, and you are really enjoying the program. Oh, I'm so excited about that. Thank you very much. Subscribe to the channel, like the page, and then definitely we'll keep sending you notification whenever we put content on our pages. Thank you, thank you, thank you so much. With that, I will go and show my appreciation to BWF solicitors, and when I come back, Asma will lead us in the discussion. This afternoon, what we're discussing is about UK visa applications. What are the reasons that may be given to make it invalid, and how we're going to avoid that? Stick and stay. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you very much for sticking around, and welcome back. Yes, and now to the main discussion. We're looking at reasons why UK visa applications may be deemed invalid and how to avoid that. Now, Asma, invalid applications are likely to be refused. Um, is that always the case? Why are they giving reasons why it's invalid? There are questions that they pose on the forms. We complete all of that, answer them to the best of our ability. Why would they be invalid? I think these are thoughts running through the minds of my viewers and listeners, and I'm grateful that you are here to help us with that. Now back to you and in your court.
Thank you very much. Viewers and listeners, once again, good afternoon. So, we are going to have a conversation, and today's conversation is something that may not necessarily be bothering most people.
Mhm.
However, the factors we are going to discuss are things that often come up, and on that basis, people's applications are rejected as invalid.
Okay.
And some people sometimes will also call a lawyer to ask, lawyer, this is the situation I find myself in. What do I do? And the lawyer may point them. So today we are going to have that conversation that a lawyer will have with you,
Mhm.
which you normally pay money. And as community lawyers, we come and give you this service all at our own cost.
Mhm.
Now, this conversation is about what will make my application to be invalid.
Invalid. Okay.
So the question is, does it mean that an application can be considered invalid? And if it's considered invalid, what happens to the application itself?
Okay.
If an application is not valid, it means it will not be looked at. If it is not valid,
If it is
it
not valid, it won't be looked at.
exactly, because we look at valid applications in terms of assessment for decision, right? So
Mhm.
if the application is not valid, why would the caseworker waste time to assess it? On what
So
basis?
if it is deemed invalid, it doesn't mean that he has been refused, but it won't be touched at all.
Exactly. So that they don't
Okay.
waste their time.
Okay.
And if you are lucky, the caseworker might tell you that it is not valid, fix it. Well, if you are not lucky, and they say, well, you should have known.
Mhm.
And so equity favors the wise, not the foolish. And since you have not been wise and brought us something that is not valid, we cannot apply equity and make say that it is fair for us to consider it. No.
Okay.
And so it's a very simple but very important
Mhm.
in that imagine your application is considered not valid. Meanwhile, your visa ran out. At the time they told you it is not valid, you are an overstayer anyway, but you are protected under Section 3C. So you have moved from the body of your visa to the spirit of your visa.
Mhm.
And they tell you that your renewal application or your switched application is not valid. You'll be worried. The stress alone. So this conversation is to let us know when we are making applications, what is it that we have to do so that the caseworker wouldn't even suggest that it is not
It
valid.
is not valid. Yeah.
Right. So, one, every application has to first be valid before the caseworker will check whether the requirements are met. For application to be valid, you have to look at the form. So the first thing that will make the application invalid is the form, the application form itself.
Mhm.
There are different applications and therefore different forms. If you use application for indefinite leave to remain, Babako, and I'm going to ask you this question. This is not law. If you use an application for indefinite leave to remain for naturalization, application because you want to naturalize, you want to become a citizen. Meanwhile, the application form you failed and submitted if for it's for indefinite leave to remain. Will they go ahead and make a decision for citizenship?
No, that's not what you asked for.
That's not what you asked for. And so it is obvious that the application form is wrong. And if the application form is wrong, the caseworker will tell you that it appears that you have used the wrong form. So go back and do it again.
Okay.
That will waste your time That will waste money because you have to pay and later get the money you paid back. And if
Okay.
you don't have money to pay again and get the first one back, that is trouble.
Mhm.
So the application form, it's important that when you are making application, you check whether the form you have used or chosen is the form for the type of visa application you intend to submit.
Okay.
Form is
And
important.
to a lay person, I am applying to extend my stay, for instance, and I think that I am empowered or I have the know-how to do that, then I go on to pick up a different form. Uh, I am hesitating to say, would it be always best for us to be talking to immigration specialists who have been licensed to do that? Because then we can avoid this pitfall.
Yes, that is why a stitch in time will
Saves
always
nine.
save nine. Because if you are not sure, why do you try it yourself? Because it's not something that you have to gamble.
Hmm.
If you gamble, you are buying stress for yourself and also buying extra cost for yourself. So why
Hmm.
do you do that? At least speak to a lawyer by way of consultation. Once you have an understanding, if you think you can do it, go ahead and do
Go
it.
ahead and do it. Okay.
But if after talking to the lawyer, you believe that the lawyer should do it for you, and trust the case to the lawyer, sleep and let the lawyer deal with your problems for you.
Okay.
And that is what you are paying for, to sell, to exchange your trouble so that the lawyer will take it up. And something happens. It is the imagine the lawyer does the application for you or submit the application for you, and the whole caseworker says that the application form is not correct. Whose fault is it?
Your own. The
No, no,
application is
that's
for
the
you.
lawyers.
Oh, you give it to a lawyer. Sorry. So you
Very
give it to a
good.
lawyer, then it becomes the
Very
lawyer's
good.
responsibility.
Exactly. So in this case, the lawyer will deal with it for you and make sure that you are not become a victim of this. But
Hmm.
if you did it yourself and something has happened like that, it's your then you give it to a lawyer again, having had issues with it. You pay the lawyer, you pay home office fee again for the lawyer to submit for you.
Hmm.
Time wasted, money wasted, and all the inconvenience and anxiety you put on yourself. So
Okay.
it's important that if you are not sure, get an expert to deal with it for you. An
Okay.
expert, I mean expert. We have semi-experts and complete experts. I will propose that I look for complete experts. Because the semi-expert may just be like you. The semi-expert are the pocket lawyers.
Right. So we've looked at one of the situations that could make an application invalid. Is that the only one?
There are a few more. So the next one that may make the application invalid is submitting application without a valid passport.
Okay.
So you realize that when we touch the issue, we look at how to avoid it because we said that what are the reasons and how to avoid
How
it,
to
isn't it?
avoid those? Yeah.
So we are addressing both.
Hmm.
So the first reason is the form. How do you avoid it? Make sure you have selected the right form. If you are not sure, speak to a lawyer. And if you are not sure, give the case to a lawyer to handle it for you to
Hmm.
avoid the risk of
Of
completing the wrong
making that
form.
application invalid. Yeah.
Good.
Okay.
The next one is submitting application. This time it is the correct form. You've submitted, you've paid your fee, but you didn't add your passport.
Hmm.
Then the application will not be valid.
Okay.
So why will I say somebody didn't add a passport? You may have the passport information,
Hmm.
but the passport information you have are for the old passport, expired passport. If the passport is expired, then you have to show that you are making a new one.
Okay.
That's to avoid the application being considered invalid because you didn't add your passport when you went for your fingerprint. You have to make sure that one, when you were making the application, you use the expired one. If you don't have an expired one, You say that I don't have it, but you are in the process of getting one. So you have applied to your country's embassy for a passport,
Mm-hmm.
and you have printed the passport application form. You have an appointment booked, and you have added that to your visa application document, so
Okay.
that they know that even though you don't have a passport, you intend to get one.
To get it. Okay.
You intend to get one. That is also fine. That is also fine.
Okay.
Then the
So
third
so
one,
so on the passport, if for instance these days the application goes to the Home Office and it spends almost a year, which is becoming the norm. If I have a passport which is expiring 6 months or so from the time I'm putting in the application, what do I do? Does it invalidate it because the decision will not be made and my passport will expire?
okay. So the key question is, at the time of your application, was your passport valid? Yes, and that's it.
Yes. Okay.
If it was valid, why didn't you add it? Unless it is with the Home Office. The rules say that if your passport is with the Home Office, then you don't have to. Otherwise, I mean, that is logic, isn't it?
Okay.
I have to give it to you, but you have already taken it from me. So if I have to give it to you subsequently, I will only tell you that remember you still have it, so use it.
Okay.
So if the passport is already with the Home Office, then you do not have to worry. That is an exemption.
Okay. All right. Thank you. Yeah. If you just joined us, we're looking at what makes visa application invalid. Lawyers mentioned two of those factors. We've looked at the wrong application form and not submitting your application with a valid passport. And we would want to, if you have a question on that, keep that in the comment section below or send a text 0739920468. We'll come to that. Now let's continue with the other bits that can make a visa application invalid. Remember, we're bringing you this courtesy of BWF solicitors. Last one. Yes. What will be the next point?
So the third reason why your application may not be valid
Mhm.
is that you did not pay the right fee.
Okay.
You did not pay the right fee. Is it possible to submit an application without paying the right fee? It's possible. There's one instance. The person was meant to pay a fee because the person did not opt for a fee waiver. We submitted application for whatever reason, there was no fee there. It was showing 0 0. So
Mm.
even the word that is magic for this person. Well, that's magic happen in what we do. Well, if the application you click submit and it goes in and there's no fee paid, then it's gone. They wrote us and said that we are considering the application, but we realized that the fee was not paid at the time and there was no fee waiver. Can you please give us the card details so that we can deduct the fee and make
Mhm.
that? So, so you see that in this case, if the person doesn't pay still, then the application is not valid, and so there will be
Mhm.
no decision on it. So
Okay.
without paying the right fee is also important. Or you don't pay the IHS fee. There are instances where somebody will think that they have paid the IHS fee only to realize that they haven't paid the IHS fee. If it happens like that, they will write to you to pay the IHS fee. If you don't, then they will say the application cannot continue to the assessment stage
Mm.
because you haven't complied with the validity requirements.
So we have incorrect form, not adding your passport, and not paying the correct application fee. So if
Yes.
you are completing the form and it says 0 0 and you have not made an application for a fee waiver, please try and find out and pay the appropriate fee because you may not have a caseworker bringing that to your attention. Would that always be the case where the right fee is not paid and they bring that to your attention?
If it's about a fee, then you could see that it's a technical issue.
Okay.
because there's no way an application will go through if the fee is not paid.
Mhm.
And for the application to have gone through without the fee payment, then it's obvious that there was technical error somewhere, which favored the submission at the time.
Okay.
And so it's only fair that the person's attention is drawn to that and for the person to make the payment that should have been made.
Okay. All right. So
So
yeah,
the
what will
next
be the
one,
next one?
the next one is making an application. That's the fourth factor or reason.
Mhm.
Making an application without enrolling your biometrics. We call it
Okay.
fingerprint.
Mhm.
So as part of the rule, the um, policy focus of the government, every application is now every visa is now going or has gone electronic. So if you make application, whether before or now, you have to enroll your biometric data. Whether you did it from abroad or you did it from the UK, wherever, you have to enroll your biometric data, what we call attend the finger for your fingerprint.
Mhm.
It's easier for people to understand. Go and scan your fingers and face. If you don't, they will remind you. And if you still don't, the application will be considered not valid. Because a complete application is one that went or that was submitted with the right fee and right biometric data. So it's
Okay.
important that once you have submitted your application, if a lawyer submitted it for you, ask the lawyer, when am I going for my fingerprint? If the lawyer doesn't talk about fingerprint, then they did some different application just to make you happy. Look into it. Because every application, you must have it. Somebody called me last week and told me that my lawyer did an application. He doesn't want to tell me what application it is. And I said, oh, but it's your application, so the lawyer should tell you. And as a
Mhm.
matter of fact, when you went for your first consultation or gave the instruction for the lawyer to do the application, the lawyer should have told you what they are going to do for you. So
Right.
for the lawyer not to have told you, and for you also not to have asked the lawyer, and all you are telling me is that the lawyer said something will be done. I said, okay, that's fine. To be able to know what was done, give me application copy. Person said that the only thing I have is the checklist. So I said, give me the checklist. And on the checklist, you can tell the type of application and the fee paid made. That
Okay.
was so I got the checklist and I was able to tell that, oh, but this is skilled worker application. The person didn't even know. So I said, yeah, this is a skilled worker application because it's there, point based, PBS, blah blah blah, and you paid 500 and something, or 500 and something was paid. Then she said, oh, but I don't have a COS, and the lawyer said they cannot. So I said, well, that's what I see. A skilled worker visa was submitted for you. If you don't have a COS, the lawyer might have said that COS was not ready at the time and was submitted anyway. So your job now is to make sure that you get your COS. Otherwise, the application cannot proceed to the next stage.
Oh, okay.
Then she said, oh, I didn't know about all this. I said, then go back to the lawyer. Ask the lawyer to give you the application form. Because when you submit the application, you can download the form. We at BWF Solicitors, we usually download the form and give it to the client by WhatsApp or by email for them to download and keep it.
And keep it. Yeah.
It's their data. Or we'll print it for the person to take home. And as a matter of fact, we even before the person application is submitted, we give the draft to them to review before we submit. Because we believe in working
With
directly with
the
the client,
client, yes.
collaborative effort. You
Mhm.
don't do something for somebody without the person knowing what you are doing for them.
That
And that's why we
that could make it invalid.
well, that could be valid, but get them involved so that they know what is going on their behalf. And that's
Mhm.
what we do here. So this person, I said, go and get the form. She called back and said, the lawyer says they can't give me the form. I said, how? Well, for me, there's nothing I can do. But what I know is that they should have given you the form to even know the information that was included.
Mhm.
Since you don't know the type of application, you want to know what exactly is said about you. Because if it is a skilled worker, you want to know whether they put in any COS at all or they didn't put COS. Because without COS, your application cannot be decided. So I gave the person all the information needed. And I said, well, now it is your decision what you want to do. You gave the lawyer instruction. The lawyer did the job for you. You paid the lawyer, and it is your right to know more about your own application or job. So what we are saying is that make sure that you have enrolled your data, which is the biometric, as part of the application. Otherwise, the application will not be valid.
So, completing the right form, adding your valid passport, paying the right application fee, enrolling for your biometrics. These are four factors we have already looked at. And I
And
believe it's got you thinking, have I done any of these? Have I missed any of these? And if you spoke to a lawyer and the lawyer did the application on your behalf, if you could, please insist on a copy review before it's submitted so you know what's going for you and on your behalf. We write on the community and the launch brought to you by BWF Solicitors, our trusted partners when it comes to the law. Last one, are there any other factors that could make any application invalid?
yes, so one more to make
Okay,
the five factors.
all right,
So one more factor is to do with EU applications.
okay,
And this factor is exclusive to EU applications,
right.
whether you are applying for pre-settled status or settled status.
Mm-hmm.
They will ask you to explain why your application has been submitted late.
Okay.
Why your application has been submitted late. Because under EU rules, Appendix EU to the immigration rules and the withdrawal agreement of 2020, there's a proviso that if an EU national or an EU national family member submit an application after the deadline, and the deadline here was the 2023 August final deadline. If you
Mm-hmm.
submit any application after that date, you must give a reason why. They shouldn't reject it automatically. If the person gave a reason, it has to be considered. If
Okay.
there's no reason, then it will be rejected automatically. And so the caseworker will only be applying the provisions within that rule to say that you submitted application, which is a EU application. You submitted application after August 2023. The application is already late, and you didn't give reasons why the application is late. Therefore, the application is not valid. So anytime you see EU application submitted and the person receives response to say that the application is not valid with reasons given, you know that the application was submitted without reason for lateness.
Well, um, we can say it's any way better than this. Make sure, as lawyer said along the line, a stitching time saves nine. Do the right thing. Speak to a professional to do what is right for you. Complete the right application form, the correct one. Add your passport. Pay the right fee. Enroll for your biometrics. And particularly if it's about EU and you have applied late, provide a reason why you did not apply on time. BWF Solicitors, talk to us 0208 493 7340. We're on the top, on the fourth floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters, North London. You can call us Monday to Friday between 9:30 and 6 p.m. In emergency situation, 077 127 61884. Those of you outside of the UK and in Ghana, you can make use of our office in Accra by calling 055 589 5959. Good evening. I'm trying to ask a question, but the WhatsApp number display seems not to be active on WhatsApp. 07399 208 468. 07399 208 468. That's the number for both WhatsApp and text. Yes, there are two numbers on there. Ignore the very last one. We'll get that corrected. 07399-208-468. BWF Solicitors are trusted partners. We're going to say thank you to them when we come back. We will be picking up your calls on 0208-493-7345, 0208-493-7345, or you can send your comments to our comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV. And then again, you can send a text as well on the number, as I have read already, 07399-208-468. You can see those numbers at the bottom of your screen. Our resource person and guest this afternoon is lawyer Charles Asma from BWF Solicitors. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around live on BWTV, and the program is The Community and the Law. This is brought to you by BWF Solicitors. This afternoon, we have been looking at reasons why a UK visa application may be invalid and how to avoid that. Our resource person and guest is lawyer Charles Asma from BWF Solicitors. Now the lines are active, 0208-493-7345, or you can send a text or WhatsApp to 07399-208-468, or leave your question in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV. I recommend BWF Solicitors for anyone with immigration issues. With a love emoji, Ernest Jesse says that thank you, Ernest, for your feedback. And then we move to the next one. As I said, the lines are active, so when we have somebody on the line, we'll put that across to Asma. Good evening. Can a Monzo Bank statement be used for student visa application for the UK? Wow.
Yes, Monzo is a recognized bank. So if you need to submit bank statement to show maintenance, you can use your UK recognized bank account statement.
Okay. So I think, yes, Monzo is a recognized bank here in the UK, so you can do that. The next one is coming from um, Dabi Obed. He brought it earlier on lawyer. He says he has B1 in the English language test. Did the exams last month in February. Can Dabi use this for his indefinite leave to remain? He says he's on the spouse route.
So B1 in my English test. I did the exam last month. Can I use it? My hello. Well, Obed, you could have spoken to me. You know, I'm doing your renewal application. The B1 you have done is for the renewal. What do you call it? For the renewal application. If your and this renewal application, once it is granted, will be due for further renewal, which will be your indefinite after 2.5 years. And that time, the new law has kicked in. So if the new law is kicking in, and already they are saying that from 26th of March 2027, everybody doing or putting indefinite leave to remain application must have B2, and you had B1 for your second renewal of FLRM. You cannot reuse it.
Mm.
So you have to do it when you get there. But you don't have to worry because your indefinite will be about 3 years' time or 2.5 years' time. So
Well,
let's
Leah, you remember you said yourself earlier today, a stitch in time saves nine.
a stitch in time
Open the
saves
attempt.
nine. But the point is, if it's a stitch, but
Mhm,
he says that can I use it?
mhm. Open the attempt.
No, he could have then said that, is it okay for me to do my B2 and keep it for future? Then the
Okay.
answer would have been yes. But he's asking, can I use my B1 again? Because I did it last month.
Mm,
You did it last month. Even if you did it for indefinite leave to remain, you cannot use it because your indefinite leave to remain possibly will be before. If it is before next year March, then that's fine. But whatever you did, the English language test result you have is for your renewal, not for
mhm.
indefinite.
Okay.
That's the
Well,
difference. He
well,
did it for his
Obed,
renewal.
I guess probably it's not the answer you were expecting, but the truth is you can't use it. By the time your indefinite leave to remain application is up for putting in, if I can use that expression, then you would have to do the B2.
Yeah.
I think
So,
what I gathered from lawyer is that you can do the B2 now, and then it will be valid at the time. Well, keep it coming through. 0739920848. Put them in the comment section or give us a call 0208 Maximus Bank says, I'm really lucky today. I need to book an appointment for my issues. Thank God I joined this live. Yes. This is a very beneficial program for the community. And once you're part of it, yes, spread the word, share the link, invite people to join us. You can book an appointment, call BWF Solicitors on 0208 493 7340 and make an appointment to see the lawyers. Let's pick up the next one. Reigned of Double, Margaret and Kwabena are legally married and have a child born in the UK. Margaret has been issued a certificate of sponsorship from a care company. Can Kwabena be hair dependent?
okay, so the certificate of sponsorship from a care company, right?
Yes.
It means this is a care COS, which is likely to be 6135, 6136, or even 6131, which is the auxiliary nurses role.
Mhm.
Now, Kwabena didn't, is it, Randolph didn't tell us when this was issued. So Margaret has been issued. When?
Mhm.
When was this issued? And that is important for response.
So if it was issued before the new directive came in that COS for care workers does not allow them to bring in their partners, then they could have Kwabena as a dependent. Is that correct?
So then let's situate it by adding our own conditions. Condition
Mhm.
one, Margaret was issued with COS before 11th of March 2024. then Kwabena can be a dependent.
Okay.
2, Margaret was issued before 11th. Margaret had one before 11th of March 2024. It expired and the company renewed it and issued another one after the new law has come into force recently. Kwabena can still be a dependent because Margaret was a skilled worker, main migrant before the changes and continues to be.
Okay.
Yeah, so that's the difference. If
Yeah.
Margaret was and the employer has issued a new one to renew the contract for Margaret,
Mhm.
then because she was there before 11th of March 2024 as a skilled worker care, at that time she had not met Kwabena, she was single.
Mhm.
Then she renewed it in somewhere, let's say December 2025. At that time, she had met Kwabena and they had had a baby and so on and so forth. Can Kwabena and the baby go on this? Yes, they can, because Margaret was before and continues to be a skilled worker migrant.
All right. Well, Randolph, thank you for your question, and Laura, thank you for the answer as well. We have a couple more to look at. Ruby is asking what happens when applications become invalid, not being able to submit any COS. Laura.
So, what happens when application becomes invalid of not being able to submit any COS? So, I'm going to answer this with live situation.
Mm-hmm.
I submitted my client application because her visa was expiring. Thank God she had COS. So we submitted a year ago. Last week, I received an email from the Home Office saying that the employer's license has been revoked at the
Mm-hmm.
time they were making a decision on my client application. And so they want me to confirm to them whether one, my client will be happy to withdraw the application so that they will not say that it is, so that they don't refuse it.
Mm-hmm.
Because once they refuse it, my client has become an overstayer. Once she withdraws the application is no more. She has still become an overstayer. And the third option for her is for her to put in an application so that we vary the one they are considering to refuse. The reason is that the license has been revoked, and so the COS is no longer valid.
Okay.
And it's the same thing here, isn't it? What happens when application becomes invalid for not being able to submit any COS? If your visa has already expired and they have given you an option, then you can put in a new application so that your 3C protection will remain. But the moment they go ahead to say your application is no longer, it's not valid because of no COS, then that's it. You become an overstayer because at that time your protection is no longer active.
Okay. Well, sometimes it demands that we get to the professionals so they can explain things very well for us because some of these situations, if you left them with me, I may not be able to give you that accurate and cogent answer. Let's make other ones here, and you can keep them in the comment section below, as I said, at BWF Solicitors, both on Facebook and YouTube, and at BWF Solicitors, and at BWTV on Facebook and YouTube. My brother came to the UK with care. If his wife did not pass a test, can my brother renew his paper? My brother came to the UK with care. That's maybe a COS, I should say. If his wife did not pass a test, can my brother renew his paper? What test? I don't know. Well, I don't know whether you can
Well,
submit it and it can
let's
be
make
counted.
assumptions here.
Mm-hmm.
We are assuming that the the lady, I don't know why, if the so my brother came with care, whether he came as a main skilled worker or dependent. If the
Mm-hmm.
brother came as a dependent of the wife, and at the time, for example, the wife, but if the wife had came as a skilled worker, then definitely we will assume that she passed the English language and subsequently she doesn't have to. But let's assume that the brother came as a male skilled worker and the brother is switching to the wife who is maybe planning to switch to care. Even so, we are making a lot of assumptions because charity is
Mhm.
not clear in the point she raised. Then, if the wife did not pass, then the wife cannot have the COS or cannot apply for the skilled worker. So the dependent cannot join her, unfortunately. So, charity simply, if the wife is in trouble, dependents are in trouble. Okay. But we don't know what the dependent has to avoid trouble. But as long as the dependent is following the wife, if the wife falls into the gutter, they are all in the gutter.
Keep them coming through. Let's pick what you have sent in. Your WhatsApp and all the other ones are also available, so you can text us through that. I was granted indefinite leave to remain under EUSS as a spouse to an EU national in June 2025. However, before I was granted a pre-settled status in June 2020, I had overstayed my visitor visa for about a year and a half. I would like to find out, like, if overstaying my visa will have any consequences on my British citizenship application. How would that be treated under the character reference requirement? If yes, what are my options? This is from JJ.
Right. So, the, under the citizenship rules or
Mhm,
within the rules for nationality applications, suitability will usually be for people who enter the UK illegally.
mhm.
Entering the UK legally and overstaying and managing your life up to this point can only delay your indefinite leave to remain. Thank God, the path you took has no restriction. And in any case, you already have your indefinite leave to remain. So your overstay situation before going through the EUSS, meeting your wife or husband and doing all that you did, and you were granted your indefinite, your pre-settled, getting your indefinite and all that will not affect. If you are not sure, give the application to a lawyer to handle it for you so that you have your peace.
Give your application for a lawyer to handle for you so you have your peace. And I recommend you speak to BWF solicitors, our trusted partners when it comes to the law. Let me remind you of the nuggets we have earlier on and then give you the scenario. We'll come back to your questions and get lawyer to help us under that. And in the nugget, we're saying that under paragraph ST 39.1, 39.3 of the appendix students to the immigration rules, a dependent partner of a student will be granted permission which ends on the same date as the student's permission. The dependent will have no access to public funds. And where the visa was granted for a period of less than 9 months, or the student is studying a course below degree level, there will be no rights to work. Working in breach of your leave condition as a student dependent is an immigration offense. And I quoted where we picked this one from paragraph 31, ST 31, ST 39.1, ST 39.3 of Appendix Student to the Immigration Rules, Section 24 of the Immigration Act of 1971 as amended. So, based on that and the explanation that lawyer gave us earlier on, I presented the scenario to you to help us give Delilah uh, some advice. Now, Delilah was granted leave to enter the UK as a dependent of Samson, and that was from the 30th of September 2024 to the 31st of July 2025. Samson was granted leave to enter the UK as a student from the 2nd of February 2024 through to the 31st of July 2025. Delilah joined Samson in the UK in November 2024. On the 8th of May 2025, she was arrested by the border force when she was working at a warehouse. Her leave was cancelled without a right of appeal, and she was detained pending removal from the UK. on the 29th of May 2025. According to the Border Force, Delilah breached conditions of her leave as a student dependent and thus has committed an offense under Section 24(1) of the Immigration Act of 1971 as amended. So she's asking, and I'm asking you to help us give Delilah some advice. Are we going to say to her that she has no reason to remain in the UK because she's breached the conditions of her leave since she had less than 9 months left for her visa to expire? Are we going to say to Delilah that, listen, Delilah, you cannot be removed from the UK because you have a spouse who has a valid leave to remain in the UK until the 31st of July 2025? Or it could be that we say to her, Delilah, you should seek a judicial review of the decision to cancel your leave because you have not breached the conditions of your leave as alleged by the border force. Think through it. I will later on pick up your answer. So you just give me one, two, or three, and we see what the correct answer would be from the lawyer's perspective. But in the meantime, let's go back to our questions and comments from the platform and on the phone. Ruby comes back again and it says, when someone becomes an overstayer for 9 days after receiving an email of an invalid application because of no certificate of sponsorship being submitted, after they leave the country, can they apply to another country or the UK on a student route the same year? Lawyer.
When someone becomes an overstayer for 9 days after receiving an email of an invalid application,
Mm-hmm.
and it says because there's no COS, after they leave their country, can they apply to another country? Okay, as for the another country, depends on the other country and what they accept or not accept. So I cannot comment on the other country. If the other country doesn't ask you about why you left the UK, you don't tell them why you left the UK.
Mm-hmm.
For UK or the UK on student route, yes, you can. Now, you left within nine, fine, you were an overstayer within. If they ask you, have you ever overstayed? You say yes, and you explain why. I made an application. The caseworker said my application was not valid. I was given an option to make another application or consider leaving the UK, and I chose to leave the UK. It took me 9 days to organize myself to leave, and that is why I overstayed. That is fine.
Mm. Okay. Well, Ruby, that is fine. So give a very cogent explanation, valid one, of course, and that will be considered. We have discussed reasons why UK visa application may be invalid and how to avoid that. Yes, we still have some time to pick up your questions. So if you have put them in the comment section below, we can pick that. If you have a text, 0739920848. If you, I mean, if you, what options does an overstayer have? Well,
An overstayer has the following options. One, to make a family life application on the basis that they have lived in the UK for 20 years. And within those 20 years, of course, it doesn't count being in prison, living and coming back to the UK. If you've been in the UK without papers for 20 years or for 18 years plus the 2 years you had papers, obviously you wouldn't have left the UK, so you were in the UK. And you can
mhm,
apply under paragraph PL 5.1A of Appendix Private Life to the immigration rules, which says that if an adult has lived in the UK for 20 years and currently an overstayer, they can apply for 2.5 years leave to remain under Appendix Private Life on the basis of their long residence. If the person, because it says that what are for overstayer, if the overstayer is a child, then after 7 years of living in the UK without a visa, 7 years for child, you apply for 2.5. If the overstayer is a an adult, young adult. A young adult is between the age of 18 and 25, according to the rules. If the overstayer is a young adult between the age of 18 and 25, then the person can apply under paragraph PL 5.2 of Appendix Private Life, which says that if the person between the age of 18 and 25 has lived in the UK half of their age and they are an overstayer, they can apply for 2.5 on the basis of their private life. So these are the three for private life. You can also apply under family life, where you are applying on the basis of your child, child, child. I've said child 3 times, and I will tell you why. On the basis of your child, where the child is your biological child. In this case, if the child is a British citizen, or the child is one with indefinite leave to remain, either under EU or under the normal immigration rules, or the child was born in the UK and the child has lived in the UK for 5 to 7 years of life, or the child was born and the child holds EU passport with 5 years pre-settled, then the child is a qualifying child under paragraph 117D of the relevant statute. You become a parent of a qualifying child and you can apply to remain with your child. The reason is that even though you don't have a visa, your child has the right to remain in the UK. Your child cannot be forced out. You can be forced out. But by forcing you out of the UK, it may affect your child's well being, and therefore it may not be in the best interest of the child for you to be removed. On that basis, you'll be granted 2.5. Not because you have lived in the UK for 20 years, but because you have a qualifying child whose well-being depends on your presence in the UK. That is biological child. Or you have a wife or husband who has a child whom he or she looks after, and you being part of the family helping to look after this child. And the child now becomes your stepchild. And this stepchild depends on you for general needs as part of the family. In this case, you can apply on the basis of this stepchild. This stepchild still must meet the qualifying child criteria: indefinite leave to remain, British citizenship, 5 7 years in the UK from birth, born in the UK, or 5 7 or 7 years in the UK if born in abroad, or EU passport holder child with 5 years or indefinite. These are the conditions for that particular qualifying, or for the child to be a qualifying child. Now, because the child is not your child, you have to triangulate the evidence. To triangulate the evidence, we want the child's birth certificate to confirm that the child is the child of your partner. And we also want evidence to confirm that you are a partner to this person who is the parent of this child. So triangle, that's why we say we triangulate. So for you to show that this is you have a relationship with a child, we have to establish your relationship with the child's other parent. In this case, marriage. So marriage certificate to show that you are married to the parent of the child, and so you become a step parent. Or you have parental responsibility order from court that has also made you a parent to this child by your association with the family or the child's other parent. And the third option is that you have been in a durable relationship with the child's other parent, be it the father or the mother, and that you have become a de facto parent, step parent to this child. Then evidence is triangulated. Then you can apply on the basis of this step child. I didn't mention spouse. That is why I mentioned child 3 times. Because if you go under spouse and you don't have live in the UK, you are likely to be refused unless you can prove that you meet the exception condition under EX1B. Now, what that says is that if the spouse has exceptional circumstances and that your absence from the UK will affect the life of that spouse, then there will be insurmountable obstacle to the spouse's life. Or you have exceptional life-threatening situations and you depend on your spouse for your survival, and that if you are relocated, you cannot survive in that country, then you have exceptional, what we call insurmountable obstacle to life or to survival in that country. On that basis, you have to prove that your removal from the UK or the refusal of your application will bring harsh consequence to you and to your spouse. And on that basis, it will not generally be fair or reasonable for you not to be granted. You can see that's a very high threshold point to meet. And that is why, if you can, make sure that you have a visa before you can apply under spouse, under Appendix FM. Otherwise, it may be better for you to relocate and apply from abroad and re enter. But these are the points within the rules.
Rules and for further explanation to this, for further support in all these areas, contact BWF Solicitor 0208 493 7340. Thank you to Ruby for participating in the program. We are going to the segment where I'm going to ask you to give me answers to the scenario I posed, the advice we're giving to Delilah and her situation with the border force and her visa that's been cancelled. She was granted leave to enter the UK as a dependent of Samson from the 30th of September 2024 to the 31st of July 2025. Something that Delilah was depending on was granted leave to enter the UK as a student from the 2nd of February 2024 through to the 31st of July 2025. In 2024, later, November thereabout, Delilah joined Samson. On the 8th of May 2025, she was arrested by the Border Force when she was working at a warehouse. Her leave was cancelled without a right of appeal and was detained pending removal from the UK. And this happened, this was to happen on the 29th of May 2025. According to the Border Force, she had breached conditions of her leave as a student dependent and thus had committed an offense under Section 24(1) of the Immigration Act of 1971 as amended. What advice would you give? Are you going to say Delilah has no reason to remain in the UK because she has breached the conditions of her leave since she had less than 9 months left for her visa to expire? Delilah cannot be removed from the UK because she has a spouse who has a valid leave to remain in the UK until the 31st of July 2025. Delilah should seek a judicial review of the decision to cancel her leave because she has not breached the conditions of her leave as alleged by the border force. What are your answers? Now, pick up these bits for my social media platforms, and then, as Kevin has said, answer is number one. I'll pick the rest. Yes, Kevin says is number one. Delilah has no reason to remain in the UK because she's breached the conditions of her leave since she had less than 9 months. Francis also thinks it's number one. We move on to Victoria Arizi, also thinks it's number one. The next one is Daniel Moke. Daniel says is number one. Delilah has no reason to remain in the UK. Daniela Yabua thinks it's number three. She should do a judicial review and seek to get that reversed. Emanuela Adakwa says Delilah cannot be removed from the UK because she has not breached anything. Had a valid client's visa. The partner had a valid visa, so to speak. Ameke says number three. Thank you, Ameke. The next one is Daniel Akoto. Daniel Akoto says it's number three. Thank you, Daniel. Kweku Tinkrang says it's number three. Okay, moving on. We have Who else? Seth Onuma Mills says number two, Delilah cannot be removed from the UK because she has a spouse who has a valid leave to remain in the UK until the 31st of July 2025. And so thinks James Tete. He says number two. Jella Johnson says number three. We'll move on to the next one, which is Gloria Amegashi. Gloria Amegashi says is number one. Has no reason to remain in the UK because she has breached the conditions of her leave since he had less than 9 months left on her visa. Maximus Banks, yeah, very new friend. Thank you for joining and thank you for participating as well. That tells me you have been following diligently and attentively as well. God bless. Um, Maximus thinks it's number three. Delilah should seek judicial review. Tiliduma agrees with Maximus and said number three. Thank you. The next one, maybe the last one, Theresa Donko says Delilah cannot be removed from the UK because she has a spouse who has a valid leave to remain in the UK until the 31st of July 2025. Lawyer, my friend lawyers or my friends lawyers have given various advices. One, two, and three have all been chosen. What could be correct?
Okay, so we know that our friend Delilah joined the husband Samson. Samson was granted at least 9 months as a student. Even though at the time Delilah was granted her visa, Samson had less than 9 months left. And at the time Delilah was arrested, she had few months for the visa to expire. But it doesn't take away the fact that at the time she entered the UK, she entered as a dependent of a student who had visa to study for at least 1 year at the time of the spouse Samson's visa was issued. And so it doesn't matter how long Delilah or the dependent has been in the UK as a dependent, and it doesn't matter how many days or hours or weeks left for her visa to expire. Her right will remain that she would be able to work. And if she was arrested for working and on the basis that she has breached the terms of her visa, then that will not be true because she could work up to the last date her visa expired. And it appears the caseworker got it wrong. The answer is for Delilah to seek judicial review to address the matter because if she wasn't because she was arrested, she wouldn't be given right of appeal or admin review. So the best is for judicial review, for the judge to review to say that the caseworker misunderstood the law, misapplied the law, and her visa was cancelled wrongly, and the decision will be overturned. The answer is three.
You chose three. You said Delilah should seek judicial review of the decision to cancel her leave because she has not breached the conditions of her leave, as alleged by the Border Force. Well, it brings us to the point where I want us to draw. Yes.
Yeah, let me say that this is one of our live cases. So the client was apprehended, and
Okay.
the caseworker said that, oh, you are supposed to be with your husband. Why are you here far away from where your husband's supposed to be? And the caseworker got it wrong
Mm,
because if the caseworker had said that we don't believe that you are still in a subsisting relationship, the matter would have been difficult to fight.
okay.
But the caseworker said that we think you have breached your visa because you are working. So I said, oh, there's a mistake. I took the opportunity and went back and told them that look at your law and look at where you are going. It didn't touch the relationship. It touched working without a visa. But she's right to be working up to the last day the visa expired. So what's
Hmm.
your problem? They came back and judicial review, they came back and said, we are sorry, take the matter away from court and we are going to reissue. And she was reissued. They were going to actually send her away twice. We
Oh,
got them to cancel the removal and we got her out from detention and her visa was reinstated together with that of
okay.
the judge.
That's what BWF Solicit does for you. So I would recommend call them 0208 493 7345. zero. And book an appointment, present your case, and they will work with you through it to get the rightful decision. Well, this afternoon we have discussed what makes a UK visa application invalid and how to avoid that. And Lawyer Charles Asma has led us. So I'll ask him to give us a brief summary of what we discussed this afternoon. Lawyer.
Okay, thank you, viewers and listeners, for your audience. Today we've looked at why a caseworker will tell anybody that their visa application is not valid and that they are either to withdraw the application or they refuse the application or simply not valid. They are not going to look at it at all. We've looked at five reasons and they bother on one, wrong application form. And the solution to that is that always make sure that you know the visa application you are making and the form you have selected is the right one. Two, you have submitted the application and after that enroll your biometric data. So make sure you do. If you don't, the application will not be valid. Submitting application without biometric data enrollment is makes the application invalid. Three, we looked at the fact that to submit application, you must have a valid passport. If the passport is expired and you are expecting a new one, add the confirmation or the evidence that you have made an application for new passport or to renew or to replace your passport. Add the application form to your document and they know that it's true that you have a new passport application coming. That is why you don't have one at the moment. If it is with the Home Office, point it out that your passport is already with the Home Office. That is why you don't have it. The fourth reason, as we pointed out, is not paying the right fee for the application. Make sure when you submit application, you pay the right fee, including IHS. Otherwise, the application will not be valid. And the fifth reason is for EU applications, where the person submitted applications after August 2023 for either pre-settled or settled without giving genuine or reasonable grounds why the application is submitted late. That will also be reason why the application will be considered invalid. So these are the five reasons why application could be considered invalid. And the explanations we have offered are things you can do to avoid such invalidity declaration. Thank you very much for your audience.
And thank you very much for your time. Thank you very much to you and the BWF Solicitors crew for allowing us to come your way every Saturday afternoon on the community and the law. Asma, thank you. Thank you so much. Maximus Burns, can't thank us enough. And thank you. And may God bless you as well as you are wishing us. We expect you to come join us same time next week. And to all of you that have sent in questions, have made contributions, have stayed on, shared the page, liked it, and subscribed to the channel, we say thank you very much. We'll do it again same time next week. I have worked with Lawyer Charles Osman as a resource person and guest. Sheila and Partner do have done the production in the background, aesthetics, and all the admin. And my studio producer has been Professor Ade. My name is Ulrich Frimpong. Have a good evening.